The phone number is not.
Okay. All right. Here we go. All right. Directed to physicians. These next couple slides, I'm going to go through kind of quickly because we've already talked about a little bit, and then we're going to talk about designation of guardianship for minor children, and then we'll come back and open the floor up for questions because, you know, it's the old saying, you know, to build a good house, you have to have a good foundation. So what I've been working on is building your foundation of knowledge concerning estate planning and how things fit together. Once I complete that, then you'll have a better understanding how it all works, and then we can, whatever questions you have, we can answer, you know, more comprehensively. So, physicians, directed to physicians is known, used to be known as a living will, and this is if you are terminally ill, if you no longer have brain function. Do you want to be on life support or not? You decide while you're healthy what kind of life-saving procedures you would like, and you can. It's a little bit like a menu. You can pick and choose if you want to do not resuscitate, or if you don't want blood transfusions or different things, and it's unique to each person. Financial, medical, and guardianship powers of attorney. So this is all brand new stuff for January 1 of this year. The purpose of a power of attorney is to have somebody appointed to act on your behalf when you can no longer make those decisions. And so they break out to different categories. Durable, and you know, reading through different things. Durable just means that if you're alive but become incapacitated, that the grant of the authority continues to exist. All powers of attorney terminate upon death except for the guardianship regarding minor children. So we're going to look at that. So we create 4 different powers of attorney. The disadvantage is that third parties like banks, real estate brokers, stock brokers don't like dealing with whoever you designate as the attorney in fact. And the reason is it's all risk and no reward. What I mean by that is that if I appoint Sheikh as my attorney in fact, and I write the best financial power of attorney that is possible, and I tell Sheikh, hey, I want you to go buy some real estate for me. So he does, and he finds a good investment, and he tries to sign the documents on my behalf to buy it in my name. The title company or the seller or any of the parties involved in the transaction may say, well, I know you've got this piece of paper, but I don't know if I'm going to rely on that piece of paper, because over time people have abused and misused powers of attorney. So for a bank, you know, if same deal, I need Sheikh to go make a payment on rent for our office or something like that. He goes to KeyBank and he tries to write a check on my account. It's very easy for KeyBank to say, no. Even if they're wrong, right? No. Because if they say, okay, go ahead, and it turns out that that piece of paper that they had, that power of attorney, was fraudulent or fake or been revoked, now KeyBank's on the hook, right? So they exist, they have a purpose, but when you're dealing with other parties, they're kind of standoffish about it. Now, what I want to talk about is designation of guardianship, power of attorney for minor children. The state where the minor child resides has jurisdiction over the best interest of the child. So if you live in Washington, Washington State has jurisdiction to determine what is the best interest of the child. And these are the new RCWs. I put them up there for some of you who want to look this up. The designation of power of attorney for minor children that I draft, what it says is that the undersigned is authorized by the Uniform Power of Attorney Act, the new one, 2017, as principals domiciled and residing in the state of Washington. So that's the key. If you designate a guardian, they are subject, they don't have to live here. They can live someplace else, but they're subject to the laws of Washington. To act for the principal for the benefit of the children, except effective upon the disability or death of the principal. So where the other powers of attorney, medical power of attorney, obviously terminates upon death because gone. And the financial power of attorney terminates upon death. The designation of guardianship for minor children continues to exist even after you pass. The attorney fact acts as a fiduciary. It authorizes the guardian to consent to medical treatment or surgery as well. So, the question has been posed, well, what if you want to pick somebody other than your spouse as the guardian for your minor children? Can you do that? And the answer is yes, you can. I don't know if a court's going to enforce it or not. And most of the time, for everybody who has minor children, we always create this. Classically, it's not a dispute. Classically, it's if both parents are gone, who steps into the shoes of both parents? Every now and then, people don't agree. So, wife can pick whoever she wants, and husband can pick whoever he wants. And if the issue never comes up, well, nothing's a problem until it's a problem, right? But if you were to die, this is the only document that's left that speaks upon the deceased person's wishes. So it's admissible in court. The court would consider it. I'm not saying you're going to win who you would pick, but at least you have the evidence as opposed to no evidence. And like I said, it's brand new, 2017. There's no cases on it. Just reading it, the black letter of the law, that's the way it should work. Okay? Good.
So, is there any difference if the child...
So Chris,
can
you go?
Oh yeah, we got to follow the new rule. Yeah. There you go.
Sorry, I have to enforce it.
Yes, I can. So, is there a difference if the child is a US citizen and not a US citizen?
No.
Is there a difference if the child is a US citizen and not a US citizen?
No. It depends on where the child is domiciled at that time. So, and to clean up something I said earlier about your domicile is where you file your taxes or your driver's license, all that. And classically, you have to reside in the state for 90 days for that to be your domicile. Same is true with the child. If the child is not a U.S. citizen, the state of Washington, if they are domiciled here, still has jurisdiction to decide what's the best interest of the child. And you know, a lot of you are young, but some of you might remember the case that happened in the refugee in Florida a few years ago. And it was a fight between Florida and Cuba over who gets to decide where the child should go. Should they stay in Florida with the family, or should the child go back to Cuba, right? And it's decided it's the state that you reside in. And obviously, it's good to be the king, right? You know, so if the king makes the rules, that's the golden rule, right? Who has the gold makes the rules. So, surprisingly, the state of Florida decided the state of Florida has the right to decide, because that's where the child's at, right? So, now Cuba probably would decide something different, but the way it is in Washington is we say, yeah, if the child's here, we can decide what's best for the child. Any other question? Yes.
So this can also be replaced by a will for the guardianship for the minor kids. So if I don't have this document, but I have it in a will instead, would that work?
The answer is theoretically yes. I've never done one. There is a provision that you can do a testamentary designation of guardianship through a will. However, you gotta die first. You gotta hire a lawyer. You gotta do a probate. You gotta dispose all your assets. You gotta get somebody appointed. And then you could create the guardianship. So there would be a big expense and a delay to get there, where this shortcuts it. This is 4 or 5 pages, and no time delay, no expense. In all the estate plans that I do, if you have minor children, you get this. You get the health care, you get the HIPAA, you get the designation of guardianship, you get the guardianship for you, you get the whole thing. And the reason is because you might need it. So I give it all to you. Same thing. The attorney-in-fact shall not have the power to revoke or change any estate planning. So if you designate a guardian, so these are different tools. The trust is different from the will. The will is different from a power of attorney. The power of attorney for financial is different from the health care. The designation of power of attorney for a minor child is different from the others. So if you set up a trust or a will, and you designated certain gifts to go a certain way, the designation of the guardianship for the minor child cannot change whatever estate plan you put in place. So,
Excuse me.
wait, he's coming.
My question is about special needs child. I have a son with autism, so will he always be considered a minor then? My son has autism, so does it mean that he's always a minor?
Special needs?
Yes.
Yeah. So in that situation, we create what's called a special needs trust. We do both. You do the designation for guardianship, and you also, in the trust, we create a special needs provision for his share, whatever you want to leave him, and that share will be managed for that child's life. And then we also provide what's called residual beneficiaries. So my son's name is Logan. So the way it would read is something like this. 50% share to Logan Benson to be held by trustee, my wife, or somebody else for his benefit. And then in the special needs provision for the trust, it would say that the trustee has absolute discretion to spend money or not spend money for his benefit, but if he dies without spending all the assets that I left him, then it goes to my other daughter. So you do both.
Is
Okay.
is the power of attorney executable after death of the person who signed the power of attorney?
No.
Yes, this is the
Yeah.
This is the question.
So you heard the question.
Yeah.
You have to make the power of attorney while you're alive and competent.
Yes.
And this kind of goes back to the beginning. We'll have people come in where somebody's been diagnosed with Alzheimer's or dementia or something like that. And the family's like, well, we need to sell the house or we need to do something for the person. The person doesn't have the mental capacity to know what they're signing, so it's too late to do a trust. It's too late to do a will. It's too late to do a power of attorney. And the standard is very low. The standard for doing testamentary provisions and powers of attorney are, you need to know who you are and the fruits of your bounty. Weird saying, but that's it. So you need to know that you exist, and you need to know I'm married or not married, and I have children or I don't have children. You don't need to know who the governor of Washington is. You don't need to know anything, but you just need to know that. And I have some people that come to my office and don't know who they are, or that they're married or not married. In those situations, cannot do estate planning, cannot do power of attorney. And powers of attorney all terminate upon death except for the guardianship. Oh, yeah.
So what are the boundaries of disability here? Like what's the meaning here, the disability? Like what and
Yes.
where it resides? Is it just a mental disabilities or?
No, it's when two physicians say that you're mentally unable to manage your assets or care for another person. So you have two doctors say, I've examined the person, they don't know who they are or the fruits of their bounty, or they don't know what's going on. They're a danger to themselves or other people.
What about in the case of like some accident or something out there in the hospital or something?
Yeah, where you're in coma?
Yeah, coma.
Yeah, that's disability.
This is
You're not able to manage your own assets. That's a great question. And disability doesn't have to be forever, right? You could be incapacitated, be in a coma, so to speak, and then wake up from the coma, and then you can regain capacity. And the same is true with people suffering from different mental illnesses, Alzheimer's. I would love to tell you a story, but I can't. But one client of mine, he had the type of dementia where there would be moments where he's here, he's with us, he remembers everything, totally lucid. And then there's other moments, which are more and more of those, where he doesn't understand who he is or that he's married, whatever. And so, in the moments where he's lucid, he has capacity. He knows who he is, and he's married, tell you about, you know, where he's worked and all that stuff, and he knows what's going on and who his kids are. But on a different day, at a different time, he may not know that. So capacity can come and go.
Is the jurisdiction automatically applicable, or we have a power to choose jurisdiction?
On which one?
On any, on a state one, on a trust one, anyone.
Yeah, if you're in Washington, if you're domiciled in Washington, meaning you live in Washington, then we have to do
No, correct, but
Washington Power of
it is a implicated by the law that we have to choose the jurisdiction of Washington only, or we have a power to choose our jurisdiction on our choice.
Yeah, you can't, and here's, I'll tell you why.
Is there any provision of the law in a law of procedure over here that we can, like in a UAE, there is no provision to select your choice of jurisdiction. There is but is there any provision here that we cannot select our choice of jurisdiction?
Okay, so the question is, can you select whatever jurisdiction you want? And the answer is, it depends. For a trust, you can pick different jurisdictions to govern what's called the situs of the trust. You can pick different jurisdictions. For a power of attorney, part of the grant of the power of attorney is that you state that you are domiciled in the state of Washington. So that's either true or false. If it's false, then you can argue, well, it's a lie to begin with, so it has no authority. That's the theory. Here's the deal. In Alaska allows you to do these kind of unique trusts where you can try to shelter assets from your own creditors. The lower 48, you can't do it. But in Alaska, they have this. I've only seen one of them, and I don't even know if it works. But the idea is that what I do is I put my house in the trust, the car in the trust, the bank account in the trust. I don't own anything anymore, so you can't sue me, and good luck trying to get to the assets. That's the concept of this Alaska trust. If you've ever been to Alaska, there's unique people up there. I love them. They're wonderful, but it's different. Everybody else, we say that's too easy, right? Because that's what we'd all do. You'd be lined up right now. I'd just stop the show and you sign up, right? I'd sign up myself. If the deal was, if you could just simply move your assets into the trust and then not pay your car insurance or medical insurance or pay your doctor or your accountant or your dentist or whatever, we'd all do that. We'd say, okay, come get me. But the deal is, it's traceable. The assets are traceable from you into your trust. However, when you die, for your beneficiaries, the trust that I draft have what's called a spendthrift provision. And what the spendthrift provision says is that the creditors of the beneficiaries cannot get to the assets that you leave them. So, I create a trust for my children. Right? I die. 2 houses in their bank account. It doesn't matter if they get married or get divorced. It doesn't matter if they pay their student loans or don't, or get in a car accident or file bankruptcy, or anything goes wrong in their life. As long as they leave the assets in the trust, their creditors can never get to it. So that's one of the huge benefits. And I read a report here about 2 weeks ago saying that in the next 22, 24 years is going to be the largest transfer of wealth in history among generations, because of the age that we all are and our parents, the age that they are moving along. That, you know, my mom and dad are 80 years old. You know, they might live to 90. They might live to 100. They might pass tomorrow. I don't know. But in the next 20 years, whatever wealth they have is going to flow through to me. And then I'm going to be 20 years down the road. Now I'm going to be 75 years old. Same thing's going to happen. So the spendthrift provision, for those people who do estate planning properly, are going to be able to shelter assets for their beneficiaries for generations to come.
The Washington law allows to write in the trust to distribute the liability proportionately written in the trust?
No, the tax liability. So what he's asking is, can you write in the trust that you distribute the liability proportionally according to the beneficiaries? The answer is no. The trust is liable for itself. Now, if there's income or depreciation or expenses, and probably the accountant can probably address this better than I can, it flows through according to your percentage. So if it's a third, and the income for the trust was 120 grand, and it's a third of each person pays based on their own tax rate. But I know enough about tax to know I don't know enough.
But the writer of the trust cannot decide by himself the percentage of the liability to goes to whom?
No.
No.
It's, the trust as an entity is responsible as a whole. And then once the liabilities are resolved, then the net distributes to the beneficiaries.
Yeah. But the property can be distributed as per the percentage written in the trust.
That's true. Yeah, you can divide a property however you want. Okay.
Just a comment on that.
Yeah.
With regards to the split clause, right, so that could be problematic
Legal put
in the sense that we cannot shelter assets from creditors if it belongs to the estate of the deceased. Right?
Correct.
So it's got to be personal property of maybe the heirs or the beneficiaries. If it belongs to the deceased, then that will have to be liquidated
Correct.
and then distributed to the creditors.
Correct.
Before we can decide on inheritance or matters of inheritance, and that is according to Islam.
Correct. Yes. Oh, for my, just use me for example. I have a trust. I have assets in it, and I have 2 children as the beneficiary. I die. My liabilities need to be resolved first. Once my liabilities are resolved, the net distribution can go to my heirs however I decide. And that's the cool thing about it. One of the main great things about trust is that it allows your successor trustee to handle that process seamlessly. They start writing checks or paying bills or liquidating assets. No court order is needed, no delay is needed. But yes, you have to resolve the liabilities of the deceased first. Yeah. Any other questions?
Yeah.
Yep.
Can I have more than one power of attorney?
Well, there is more than one power of attorney. Each one's designed to do something different. The ones that I create are ones for financial, ones for health, ones for guardianship of me as a human, and the others for my, which goes away because my youngest is 21. I had one for my minor children. So there's 4 powers of attorney. Now, can you have a financial power of attorney and pick multiple people? Can I do a financial power of attorney for Mufti Suhail and a power of attorney for Sheikh? Sure, I could do that. And that's the reason why third parties don't like it. Because I could have 10 of them out there. I could have 10 agents. It's an agent. You're just appointing somebody as an agent. I could appoint 10 different agents. 10 different people could show up. That's why, even though they're allowed, the easy thing is for a third party to say, I'm not going to deal with you. But yeah, you could have multiple ones. Good. Anything else? No. Good. Okay. So, do you want to find out what all this costs first, or do you want to ask more questions? Either way. What? Cost? All right. Here we go. And then more questions. So here's the cost. So we've been working on this for 2 months, and Mufti Suhail said, "Hey, look, will you work a deal for our following?" And I said, "I will. I'm going to give you a $1,000 discount off of our normal price. If you sign up today or you send me an email, I'll agree to do this for less money." So Seattle and East Side law firms, and I've checked this out, charge between $5,000 and $7,500 for what I'm going to do for you. They also charge $250 per parcel of real estate plus the county recording fee. What I'm going to do for you is this. Mufti Suhail negotiated a price of $2,500 for a married couple and $2,100 for a single person, and only $150 per deed. So if you are a married couple and you have no real estate, it's just $2,500. If you have 1 real estate, it's $150 more. If you have 2, it's 2 times $150, and so on and so forth. I've been doing this 25 years. I can tell you that the price of these is only going up because the value of all of this is going up dramatically. So one great thing you can do is you don't know when you're going to pass. None of us do. 20 years, 30 years, 40 years from now, you can lock this in. You can do your estate planning at today's price, at a discounted price. So you don't care what legal fees are going to be 20, 30, 40 years from now. I can tell you, when I first started practicing law, I charged $80 an hour. Today, I charge $300 an hour. And in 4 years, it's probably going to be 400, and then it's probably going to, hopefully, more. But anyway, this is good forever. And the other thing is, I don't charge for amendments. Frankly, the hard part is putting this all together in the first place. Once I get this put in, once I understand you and I understand your family and I understand your real estate, that takes me all the time. Once I get that done, making a change to your trustee or a distribution is super easy. Here's the other benefit of this, is that Mufti Suhail has agreed to review all of these to make sure they're in compliance with Islamic law. So, the added benefit you get is, you get me, not the internet. Internet's cool, but you get me, and I'm sure Mufti Suhail would do it for you anyway if you drafted your own stuff, but he and I have been working together for a unique estate plan that complies with Islamic law. So you make sure you're doing the right thing, I make sure you're complying with Washington law, Mufti Suhail make sure you comply with Islamic law, and we're all good from now on. Okay? Several things that are at the back. So, if you sign up for the registration, what I will do is I will send you an email. I will send you the presentation. I will send you the retainer agreement that applies to you, either a single person or a married couple. I will send you the disclosure waiver so that I can discuss, and if you don't want to do that, that's fine, but if you want me to coordinate regarding your estate plan, make sure it complies with Islamic law with Mufti Suhail, or some other Mufti, that's fine. I give you a disclosure and a waiver for that. I would then give you a 4-page worksheet that talks about your name, whether you're married or not married, the name of your children, the names of your parents if they are alive, the names of your brothers and sisters if they are alive, and other components that are important. I offer a free consultation, excuse me, free consultation at my office in Federal Way. We can do it by Skype, we can do it over the phone, and if enough people want to do it here, I can do it here or at a room. So we're willing to work with you however you want to do it. Yes, sir.
Two questions. One is about this preparation process. You mentioned that you've been working with Sheikh for quite a while.
20 years now.
No, on the preparation of his estate.
9 months.
9 months.
Dude,
so
that
my
guy's a
question
drag.
is, what's exactly, I mean, you don't have to use his, but what's exactly does it take? Because is that every one of them is going to take that long?
No.
Or is it like,
No. Yeah. No, I will grow. No.
that idea
No, it takes us about...
This is the question.
Okay, thank you. No. Classically, once we get to the point of the information that I need, and that might be a 1-hour meeting, that might be a 2-hour meeting, whatever it is. Once I have that information, it takes me about 10 to 14 days. That's it. So that I can draft the deeds, I can draft the stuff, to get the draft ready for you to review so that Mufti Suhail could review it. So, because there's no sense you signing it if we're not good, right? So, you tell me what you want to do, I draft it based on my limited knowledge. You say, okay, this looks good to me. We ship it to Mufti Suhail. He reviews it, he gives us the thumbs up or the thumbs down, and off we go. And then we sign it. And then the signing appointment takes about 2 hours. But it's not a long process. So it took Sheikh and I 9 months because we didn't know what the heck we were doing. We knew there were some rules that we needed to follow, and we talked about it, and I kind of gave it my best shot, but we didn't have any real guidance. And so it took us 9 months to try to fake it. But it only took me 2 months to get it right, based off of that. So going forward with you guys, 2 weeks.
The other question was, you mentioned about the real estate, 150 for,
Yeah.
what is it? The
Drafting the deed.
deed transfer.
Yeah.
So does that mean it's these properties getting into the transfer to the trust?
Correct?
So is that going to implicate into some kind of tax situation?
No, it's
or,
exempt.
like county tax and a transfer tax, deed tax, like when you sell a house?
No, it's specifically exempt moving real estate into a trust or out of a trust, there's a WAC code, Washington Administrative Code. It's specifically exempt.
And same thing in the future, operating it, so if you want to sell that house.
No. You sell, you got to pay the money.
No, I know, but is it going to be different than versus you had it individually? The tax treatment, is it going to be different?
Oh, tax treatment is exactly the same. Yeah, otherwise, yeah. So let's use an example. We have a house, we move the house into the trust, time passes, we sell the house. Your tax returns are going to look exactly the same. Your capital gains is exactly the same. The trust has no bearing on that. You live. Okay.
I was talking about the 250 break you get on the capital gains each.
Yeah, that still applies.
That's still.
250 per person and all that, that still all applies. Yeah, but if you die, then it's stepped up in value day to day. Yeah. Sir.
You want to take the question on the phone?
Oh, yes.
It's still showing up.
Yeah, no, it's still here. Oh, smokes. Okay, my question is, my husband passed away in 2007. This is a really common question. After his death, I have done probate, guardianship, power of attorney for minor children, healthcare decisions, will, and trust for my children by choosing the trusted person. Now my children are the age of 26 and 21. Do I have to change my will or trust? And the answer is no. You don't. As long as she did, I thought the way this question was going to go was different. So if she did a probate and transferred title of the assets from the deceased spouse into the surviving spouse's name, you don't have to change anything just because your children are older. However, if you have a trust and you change your mind, you can make amendments. I thought the question was going to go something like this, which is the typical situation. Typical situation is husband passed away in 2005. Wife has been living in the house, everything's been fine. Now wife wants to refinance or sell the house, and now she finds out, hey, wait a minute. Wife owns half, estate of deceased husband owns half. What do I do now? The answer is you've got to do a probate. So we do those every month, all the time, because there's no real estate police. It's not, a spouse passes away and somebody comes knocking on your door and says, hey, you need to take care of this and transfer a title. You don't. Nothing's a problem until it's a problem. So it becomes a problem when you want to sell or refinance, and then we have to do these quick probates. So we do them every month, we do them all the time, and that's the classic setup. I've probably got more than 70 going right now for that exact situation. Okay. Any other?
I've got a question here. I'd like to see that there's a few other points that I'd like to touch on as well. Right? Okay, so let me read it out. When a house is purchased, isn't the titling enough Islamically to verify ownership? Titling of property is specifically decided by the spouses. It is not automatically written in both names. This has to be signed and agreed by whoever's name goes on the title. So, touched on this issue a little earlier as well. Something that's written in title does not necessarily reflect ownership according to Islamic law. So husband and wife, because now they have maybe joint accounts, perhaps they open joint accounts, maybe for issues of immigration, etc. And thereafter the house was purchased. The husband put in all his funds, the wife did not contribute anything whatsoever. Maintenance is happening on the expense of the husband. So these actions will be taken into consideration according to Islamic law, and it will be assumed by default that the actual owner is the husband. Yes, if he clarifies it to the wife, and this is something that is not necessarily, I wouldn't say recommended, it's emphasized on him to have this recorded that he has also gifted this to his wife as per Islamic law. Now, whether the title itself will be sufficient to establish ownership, that is something which does not establish ownership automatically. We'll have to look at the situation. If husband and wife, both of them were servicing the loan, they both were contributing towards the expenses, then in that case their oath would come into play. And as Alam al-Abidin, rahimahullah, says that وَالْأُوْفُ فِي الشَّرْعِ لَهُ اعْتِبَارٌ لِذَا عَلَيْهِ الْحُكْمُ قَدْ يُدَارُ, that the urf has or the normal practice of society that has a bearing on the laws or on the Islamic laws or the laws applicable as per Sharia. So that will be then we'll look at that. If the husband and wife, both of them were contributing towards the expenses of the house, they both were servicing the loan or the repurchasing of the home, I would put it that way rather. Then in that case, you'll assume that the title itself is sufficient to establish ownership or co-ownership for both spouses. I think I've answered that question there, inshallah. Hopefully that's satisfactory. I just want to touch on one question that had come that we'll mention it after this point. But before going into that, the other question, and that question is actually directed to Chris. But before going into that, the question in a lot of people's minds, or the concern in a lot of people's minds, is that why do we have to go through so much of trouble to have our wills put in place here, or these trustees? Is it not sufficient to just write the clause or to leave instruction that when I die, my estate must be distributed according to Islamic law? Isn't that sufficient to settle everything, or I've done my duty as per Islamic law? So, that would be fine. In answer to that, that would be fine in an Islamic country, or in a country where the Islamic law would be applied, where you have complete freedom of testation, that as you have dictated, that is how your estate will be distributed. And especially according to Islamic law, this is, Islamic countries, this is how it will be applicable. The reality is that we do not live in an Islamic country, and that's why we have these other challenges around, legal challenges around it, and we have to adopt the system in order to make our wills enforceable, or our wishes that it be distributed according to Islamic law enforceable. So unfortunately, definitely it's a tedious process, perhaps it's an expensive process, as compared to somebody just signing some document or some will and saying that his estate should be distributed according to Islamic law. But if we do that, we know in our heart of hearts that we haven't done enough for our estate to be distributed according to Islamic law. That's why we have to take these steps to ensure that our estate will be distributed according to Islamic law and secure the funds for our families, secure the funds for our heirs. The question that remains, that's actually directed to Chris, is what you had mentioned earlier on, or one of the questions that was asked earlier on, with regards to divorce. What would happen to the assets, and how will that, the assets that are put into a trust. One thing you had mentioned is that gifting, and there was also a question here that came to my mind, is that any gifting that will terminate in the event of divorce. When you're talking about gifting, does this refer to future gifting, or is it something that has already taken place? That's one. The other thing is that when there's a divorce, and how do we terminate or separate these assets? You can clarify that.
Sure. You said that very eloquently, that, to comply with Islamic law, if you lived in an Islamic country, that might be fine. But you don't live there, you live here. And so the great thing about it is we found a way to make it consistent for both. So we've made it so that you can comply with Islamic law and Washington law. So writing something on a piece of paper, I can tell you from the Washington standpoint, is no good. It's as if you did nothing. The same is true if you get a bookstore. Do we have bookstores anymore? That's the way I talk, If you got a pre-printed form from wherever, Home Depot or Office Depot or whatever, and you fill it out, then what the law is that we disregard the pre-printed text and we only look at the handwritten text. And then if the handwritten text is enough to satisfy the requirements of a will, then we treat it as a will. And if you don't satisfy the requirements of a will, then it's as if you did nothing. And so I've had that happen several times, where somebody bought a printed form, hand wrote things into it, and it was their name and then a signature, and that was it. And that's not good enough, unfortunately. In the event of divorce, the assets are traceable into the trust. It's as if you did not do the trust at all, and the assets are subject to division by the court. It's just as if you did no estate planning. So whatever assets or claims by the husband or the wife are exactly the same, because it is a passive pass-through taxable entity. When I talk about what gifts are, I'm talking about gifts when you die. So if you, while you're alive and competent, you can give things away to whoever you want. A lot of times it's yourself. But if you die, so if you made a trust, you were married, made a trust, named the spouse as a beneficiary in the trust, got divorced, and then died, the gifts to the spouse go away, terminate, as if you left them nothing.
Sorry, just repeat that again.
Okay, if you're married, you make a trust, whatever assets you put in the trust, you get divorced. After you get divorced, you die. If in the trust you made a provision for your ex-spouse to leave them a percentage or a specific asset or whatever, that provision, whatever you wrote in there, is stricken through. It does not exist anymore. The law presumes that you would not want to leave your ex-spouse any gifts after you die.
Okay, that's fine. So, from the Islamic perspective, it's not even permissible to do that, to bequeath something to an heir after you pass away, right? So to make a specific direction that when I die, this property must go to my wife, or this car must go to my wife. That's not even permissible because it is it's considered as a bequest to an heir. There's no such thing as or bequest in favor of an heir. In Islamic law, it's not permissible because they will already be inheriting. They are considered as default inheritors or default heirs. So to make any type of bequest, so that doesn't really become applicable. Yes, whatever gifts were given in the lifetime, that of course cannot be revoked.
Okay. Anything else? Yes, sir. Go ahead and come up to the microphone.
I have one question.
Sure.
So is this estate planning recommended for a person who has a certain amount of asset? Let's say that if a person has just 10K worth of asset, is it still recommended for him to have estate planning?
If you want to comply with Islamic law, the answer is yes. Because if you do nothing, then the state of Washington will determine who gets your assets, regardless of what the value is. If it's $1,000 or $10,000 or $100,000. So the answer is yes from that standpoint. The ability to do the estate planning we're talking about, it's actually inverse proportion to your wealth. I'll give you a reason. Let's say you had $100,000 worth of wealth. Well, if you hired a lawyer to do a probate and you spent 4 months and you spend 10 grand, that's 10% of your wealth went up in smoke, right? But if you had $10 million worth of assets and you spent $10,000 on an attorney to do a probate, that's a very small fraction that would go to your heirs, right? It's nothing, right? So the less you have, the more you should plan. Because that way you transfer more wealth to your heirs. Make sense? Yeah. Okay. So,
I have a question for...
Yes, sir.
Whoever's got the mic, let him proceed.
Oh yeah, whoever has the mic has a question.
This question is for Suhail. Nowadays, our wives or our spouse, they are in all our financial activities, in our deeds and what have you. Not only that, but also they are earning or they are also participating financially. So in the case of one of the spouse passes away, how do we handle this situation?
So, with regards to that, as I mentioned a little earlier, that if both spouses are pretty involved in the expenses of the house, in the running of the affairs, the financial affairs of the home, then by default the title deed would hold precedence, and they will be considered as co-owners there, where there is no objection from either spouse. Of course, still the best practice is to clarify and to make it very clear in the trust deed that they own, the house on a 50-50 basis. So that would be the default ruling with regards to that. And I hope that answers your question, Lily. Just one more thing I forgot to add with regards to why it is important for us to follow this procedure. I've always had some difficulty in dealing with estates previously, especially in South Africa. The issues are very, very common as well, like how we have here. I just, with regards to personal experience as well, both my grandfathers had passed away and they left considerable amounts of properties. And because of tax issues, the heirs were forced into forming a trust deed thereafter. And I recall my father and his brothers going through a lot of time trying to formulate a trust just to save the taxes or the death tax that becomes applicable then. The same with regards to my grandfather, my mother's father, the same issues there. So inevitably the lawyers had, although they had the Islamic laws, my grandfathers had the Islamic laws in place, but inevitably even after they had passed away, the lawyers pushed for that for the trust to be formed in order to safeguard the funds from being transferred to other organizations or other individuals or going towards tax itself or death tax. And I recall the amount was pretty exorbitant, like 40% of the estate, 35% of the estate. And this is why I feel you're looking at my personal experience as well and many other people's estates. This is something that we definitely have to pay attention towards. It's definitely a will. We, from our perspective or our understanding, is that a will or last will and testament that is sufficient. But really, living in this society and living in this country, there are other challenges that also come about, and that is why I also emphasize on forming a trust deed and forming trust to safeguard our wealth.
It's cheaper and faster to do it. It's expensive to clean up problems. To prevent problems, it's super easy, fast, cost efficient. After the fact, it's very expensive and messy, and you're also dealing with the death of a person and all that family dynamic as well. So whoever edits this video, whoever that person is, do me a solid and make me look good, all right? I've been standing up here for a while and sweating and things, so make sure it looks good. I mean, Photoshop some stuff and whatever you got to do. It's fine. Yes, sir.
So this question is also for you, Sheikh Suhail. So I know that this trust, we spoke about it in the break. This trust is to go with the Islamic law and again with the state law at the same time. But my question here is what goes with the previous question at the same time. What if the divorce happens or one of the spouses or the husband basically dies, but there is no contribution from the wife, and the wife challenges this will or this document, so what happens? I mean, you know what I mean.
Yeah, so divorce will actually determine who is the real owner. Then you see the people running towards the Muftis and saying that this belongs to me, it doesn't belong to my wife at all, or the other way around, and he's got to take care of half the loan or service half the loan. So that's why it's very important to clarify it, and the Quran advises us as well that with regards to your financial transactions, that they should be recorded, and even goes to the extent of saying that it should be witnessed. But one thing that Quran emphasizes on that it must be recorded. This is something that the ideal situation, as we had explained, is that where there is no contribution from either spouse, sometimes it's the wife is contributing towards everything, or sometimes it's the husband contributing. Either way, there must be some clear provision. As I say, by default, title itself does not establish ownership or does not guarantee ownership. Sometimes a person has a car, but he put the car on his son's name for whatever purposes, maybe for insurance purposes, or the son put his car on his father's name for insurance purposes, or to save on the insurance. But the actual person who owns the car, the son paid for the car, he's servicing the car, he's responsible for the car. The actual owner, according to Islamic law, is the son. So title itself does not guarantee or does not determine ownership. Where there is only one spouse contributing, it needs to be made very clear as to who the owner is, or it will be considered that the person who is servicing the loan or is servicing the repurchase of the home and the maintenance, that person will be deemed as the rightful owner according to Islamic law. Unless now that spouse has specified that yes, I've gifted my wife in my lifetime or my husband in my lifetime 50% of the house or 20% or 30% as they wish. And the other scenario is where both spouses are contributing, then in that case the oath kicks in, or the normal practice of society kicks in. What is a zahir or a pattern will come into play, and it will be deemed that both spouses own the house equally.
Last question, please.
Last question? Okay, fair enough.
I just wanted to make a clarification about the sign up and the discount.
Yes.
Did you say just people of this masjid or anybody in attendance?
Anybody who signs up today, so you don't have to be here. Yeah, if you're here now, that counts. Southside. Okay. So sisters in the other room, thank you for your time and attention, and brothers in this room, I really, this has been amazing for me. It's been a great experience.